Yes.
This should be Antonio Blair. Is that you, sir?
Yes.
Okay, thank you.
Good afternoon. This is Judge Alyssa Perez resuming the criminal docket for the 210th District Court for March 15, 2022. All matters being heard today are being heard in accordance with all emergency orders and directives regarding COVID-19. In addition to that, we are streaming all matters live via YouTube for public viewing. Mr. Bunto, how would you call our next case, please?
Yes, Judge. This is cause number 2022-0D00533. State of Texas versus Antonio Chester Blair. Announcement to council, please.
Raul King for the state of Texas.
Eric Meza for the defense judge. We're ready to proceed.
And Mr. Blair is appearing from the jail annex. We are scheduled for a bond hearing. Mr. Mesa, you may proceed.
Thank you, Judge. Blair's been held in custody on this case since February 16th of 2022. I believe the bond set at $40,000. Mr. Blair was born in Michigan, but he's been raised in El Paso. He's 28 years old. He's been together with his wife for about 13 years. They do have 4 children. He has two from a previous relationship, and he has 2 with his wife. Prior to being incarcerated, he was working with Amazon True Up Converter Belts Construction. He had been there for about 2 months, and he's been told that he can return to work and be employed if he's released. His furthest education is about 10th grade. And as far as living arrangements, if allowed to be released, he would reside with his friend Michael Franklin at 8311 Lincoln, El Paso, Texas. After speaking to Mr. Blair, we've obviously admonished him about the nature of the offense and the CW and stringent conditions that the court would likely impose based on the nature of the offense, and he understands and he's agreed with that. As far as resources, Judge, it's pretty slim. He's the breadwinner for the family. He does have to pay rent and provide every bill and resource for them, and he is the only one working right now. Wendy, his wife, was not working. At this point, Judge, we are asking for a significant reduction based on what I've been told. He can maybe afford $500 max from the family. And so we are asking that the court consider that and we don't have a non-pros yet. However, we are in the process, I believe, of procuring one.
Okay. All right, Ms. King.
Your Honor, the state respectfully opposes the bond reduction based on a lot of factors. The first one is the criminal history. We have 2011 burglary of a habitation. He was placed on deferred, and then he was revoked to 2 years TDC, and thus to run concurrent with burglary of a habitation intended other felony. In 2012, there is a unlawful restraint and AFE. However, that was dismissed. 2013, impeding breath. He was placed on deferred and revoked to 3 years TDC to run concurrent with violation of protective order. Picked up on the same date of offense. There's also 2013 injured a child elderly, pled not guilty. 2014 violation of protective order and evading, and he was sentenced to 360 days confinement. 2014 violation of protective order that was dismissed. Another 2014 assault family violence with previous conviction was sent to 4 years TDC. 2015 possession of marijuana less than 2 ounces, that was dismissed. Another 2015 evading with a previous conviction was sentenced to 12 months state jail felony. 2015 an AFV with a previous conviction and impeding breath, and he was sentenced to 3 years TDC. And here we are in 2022 for impeding breath. Your Honor, this has been the same victim who is the girlfriend to the defendant, and all previous violation of protective order, family violence, and also there was an emergency protective order that was issued, and it is effective until April 10th of 2022.
Okay. Anything else, Mr. Mesa?
Nothing further this time, Judge.
Okay, I think the bond is appropriate, so the request is denied based on the criminal history, future safety of the community and the victim, just based on that. So 40,000 will stay. Thank you very much. Oh, but wait a minute, Chris, we do need to set this. I don't see this having any kind of trial track.
Yes, Judge, it's on my list to add projects.
Thank you very much.
Thank you, Judge.
Alrighty, thank you, Mr. Mesa. Who's next, Chewy?
Okay, Judge, we could take care of David Ibarra at the police center. So
Okay.
police center, if you could unmute, please.
there's someone at the police center, if you would please unmute.
Virtual Police Center. We're ready on Ibarra, please.
I don't know if anybody's there.
Carla.
Carla?
I sent a message, Judge.
Thank you. All right, sounds like we're good to go.
Okay, Judge, it's cause number 2021-0D0-1353, State of Texas versus David Ibarra. Announcement of council, please.
Robert King for the state of Texas.
Good afternoon, Judge Stan Flores on behalf of Mr. Ibarra. We're ready.
And do you see your client appearing from the police center?
I do see him, Judge.
Sir, this is Judge Perez. I'm going to be asking you some questions. I don't know if you're in the same room in the police center that we were using earlier, but if you are not experiencing any type of symptoms and are comfortable removing your mask, we've had some issues hearing, so I'm going to ask, yeah. Are you okay? You don't have any symptoms or anything?
No, I'm okay. Doing
Okay.
great.
All right. So let's go ahead. I'm going to go ahead and swear you in because I'm going to be asking you questions regarding your plea. If you would raise your right hand, please. Sir, do you swear or affirm that any testimony you provide will be the truth and the whole truth?
Yes, ma'am.
Thank you. You can put your hand down. Sir, would you state your name for the record?
David Perez Ibarra.
Mr. Ibarra, I'm going to be asking you about documents you may have reviewed with your attorney, the first of which is marked as State's Exhibit number 1. Those are the plea papers in this case. Within that document, you're guaranteed certain rights, including the right to remain silent, the right to trial by jury, the right to counsel, the right to confront and cross-examine witnesses, and the right to call witnesses on your behalf and in your defense. Mr. Ibarra, do you recall reviewing State's Exhibit number 1 with your attorney and signing that document?
Yes.
Do you understand everything contained within that document?
Yes, ma'am.
Mr. Flores, have you had more than 10 days to prepare a defense in this case?
Yes, Judge.
And did you explain the plea papers to your client?
I did, Judge.
Do you believe he has understood the admonishments, rights, and consequences of giving up these rights by entering a plea today?
Yes.
Mr. Ibarra, are you satisfied with your attorney's representation of you?
Yes, ma'am.
And Mr. Flores, do you have any reason to believe your client is not presently competent to enter a plea?
I don't.
Mr. Ibarra, have you ever been found incompetent by any court?
No.
Ever been examined by a doctor or psychiatrist who has found you mentally ill?
No, ma'am.
Okay, so based on your testimony, your attorney's representations, and my observations of you, I'm going to find that you are competent to enter your plea. Sir, are you a U.S. citizen?
Yes, ma'am.
Where were you born?
Ciudad Juárez, Mexico.
You are a U.S. citizen though?
Yes.
Okay, so the charge against you originally was indicted as a DWI, driving while intoxicated with a child. However, I understand through negotiations, you are pleading to the lesser included offense of a Class B misdemeanor driving while intoxicated. To that lesser included charge, sir, what is your plea? Guilty or not guilty?
Guilty.
Are you making your plea freely and voluntarily?
Excuse me?
Are you making your plea freely and voluntarily?
Yes, ma'am.
I will find you are making your plea freely and voluntarily. Ms. King, would you summarize the evidence, please?
Yes, Your Honor. Were the state to proceed to trial on the indictment, the state would have proven each and every element of the offense charged, driving while intoxicated with a child under 15 years old, beyond a reasonable doubt. Judge, the defendant is pleading to a lesser included of driving while intoxicated Class B misdemeanor, 180 days probated to 20 months of adult probation, and other terms and conditions stated on the state's plea paperwork. And Your Honor, I believe the paperwork mentions $3,000 as a fine. That was my mistake. It should be $2,000 fine. And at this time, the state moves to admit Exhibit 1 is the state's plea paperwork. Exhibit 2 is Article 3914 disclosure, and Exhibit 3 is the indictment.
Okay, any objection?
No, Judge.
Without objection, states 1, 2, and 3 is admitted. Mr. Flores, is that your understanding of the plea agreement?
It is, Judge.
And Mr. Ibarra, is that your understanding of the plea agreement as well?
Yes, ma'am.
Okay, understand the plea agreement is not binding on the court. However, if I were to reject it, I would allow you to withdraw your plea. If I follow the plea agreement, you may not appeal this case except on matters raised by written motion and ruled on before trial or by permission of the court. The next document I'm going to ask you about is the one-page trial court certification of your right to appeal. It is a document that explains your appeal rights. Because this is a plea bargained or negotiated case, you do not have an automatic right of appeal. Mr. Ibarra, do you recall reviewing the trial court certification with your attorney and signing that document?
Yes, ma'am.
It was signed by your attorney and signed by me as well. So on your plea of guilty and the evidence introduced, I will accept your plea and at this time find the evidence substantiates your guilt. I will find you guilty of the offense of driving while intoxicated, lesser included offense, and I will sentence you according to the plea agreement to 180 days confinement in the El Paso County Detention Facility that will be suspended for a period of 20 months of community supervision. There will be a $2,000 fine, 80 hours of community service, screen for TAP, urine breath analysis. There is a donation to MAD. I've seen indicated there that it's a DWI repeat offenders class, but is this a second? Is this any reason to think that this is a second, or is it just the regular DWI class?
Your Honor, this is a second.
Okay, so you're taking the repeat offenders class, curfew, interlock. You can only operate a motor vehicle with the appropriate interlock device, valid driver's license, and valid insurance. Anything further, Mr. Flores or Ms. King?
Nothing further from the state, Your Honor.
No, Your Honor.
Okay, good luck to you, Mr. Ibarra. Thank you, Mr. Flores. Who's
Thank you,
next,
Your Honor.
Sharif?
The Sosa Barreto, Judge. Annex, if we can get the Sosa Barreto.
I believe the interpreter's in the waiting room. If you
He's in
already.
already.
I think he's here now.
Good afternoon, Judge. I am here. This is Mr. Mines, the interpreter.
Thank you very much.
Will this be done consecutively or are you going?
So I think the interpretation function has just been activated. So, are you familiar with that? Okay.
He's already clicked on. Okay.
Yes. Yes, sir.
And
Sí.
Mr. Mesa, you're doing this one?
Sí.
I am, Judge.
Will you select English, please?
Absolutely.
Great.
Okay.
I just wanted,
Annex. Yeah, we need the annex, Judge. Just if they would switch over on the interpretation, please.
they're good to,
Okay, thank you very much, sir.
Mr. Mesa, I just want to confirm with you that we got the arraignment taken care of.
We did. I think we responded to, I saw my office responded to the email yesterday.
Okay, great. Thank you for doing that. I think because we switched over, you guys came in, I think we may have missed that. All righty. So is everybody here? Erin, you're here on this one?
Yes, Your Honor, I'm here.
Okay, will you select English too so I can hear you?
Can you guide me through how to do that?
It's on the bottom, Aaron, where it says,
An asterisk or some puntitos.
The
Okay, did that
ellipses?
work? Can you understand me?
Yes, I can hear you now. Beautiful.
All right.
All right, I think we're good to go. Okay, let's get started.
yes, Judge. It's cause number 2020-0D01655, State of Texas versus Raul de Sosa Barreto. Announcement of council, please.
Good afternoon, Erin Delaney Matney for the state, Your Honor. The state is ready.
Eric Meza for the defense judge, and we're ready to proceed as well.
And for the record, Mr. Barreto is appearing from the jail annex. He is also utilizing the assistance of a court interpreter. Mr. Interpreter, would you identify yourself for the record, please? And sir, do you swear or affirm that you will provide an accurate interpretation of today's proceedings? Thank you very much, sir. Okay. We are scheduled for a plea today. Mr. Barreto, I'm going to be asking you questions regarding your plea, so I need to swear you in. If you would please raise your right hand. Sir, do you swear or affirm that any testimony you provide will be the truth and the whole truth?
Sim, senhora.
Thank you. You can put
Senhora.
your hand down. And would you state your name for the record?
Raul Souza Barreto.
Mr. Barreto, as I mentioned, I will be asking you questions about documents you should have reviewed with your attorney. The first of which is marked as State's Exhibit number 1. Those are the plea papers in this case. Within that document, you are guaranteed certain rights, including the right to remain silent, the right to trial by jury, the right to counsel, the right to confront and cross-examine witnesses, and the right to call witnesses on your behalf and in your defense. Mr. Barreto, do you recall reviewing State's Exhibit number 1 with your attorney and signing that document?
Sim, senhora.
Did you understand everything contained within that document?
Sim, senhora.
Mr. Mesa, have you had more than 10 days to prepare a defense in this case?
I have, Your Honor.
And did you explain the plea papers to your client?
We have, Judge.
And how did you do that? Did you utilize an interpreter?
We did.
Okay. Do you believe that he has understood the admonishments, rights, and consequences of giving up these rights by entering a plea today?
I do.
Mr. Barreto, are you satisfied with your attorney's representation of you?
Sim, senhora.
Mr. Mesa, do you have any reason to believe your client is not presently competent to enter a plea?
No.
Mr. Barreto, have you ever been found incompetent by any court?
Não, senhora.
Ever been examined by a doctor or psychiatrist who has found you mentally ill?
Não, senhora.
Okay, based on your testimony, your attorney's representations, and my observations of you, I am going to find that you are competent to enter your plea. Sir, are you a U.S. citizen?
Não, senhora.
Okay, Mr. Mesa, have you advised Mr. Barreto regarding any potential immigration consequences to his plea today?
Yes, Judge, we have had multiple talks about parole for this type of offense, as well as the immigration implications as well.
Okay, and has your client indicated that he needs more time or time to consult another attorney? Or is he prepared to go forward with his plea?
It's my understanding he's prepared to go forward, Judge.
Mr. Barreto, understanding that there will possibly be negative consequences in terms of your immigration status with respect to a guilty plea today, have you had sufficient opportunity to discuss the potential consequences of your plea?
Sim.
Do you understand that potentially you could be subject to deportation, removal, denial of citizenship, all of those things? Do you understand that?
Sim, senhora.
And are you still asking to proceed with your plea today?
Sim, senhora.
So the charge against you, I believe, was originally indicted as engaging in organized criminal activity, but through negotiations, I believe the plea is to a lesser included offense, that being theft in an amount between $150,000 and $300,000. That is a second-degree felony. To that lesser included charge, sir, what is your plea, guilty or not guilty?
Culpable.
Are you making your plea freely and voluntarily?
Sim, senhora.
I will find you are making your plea freely and voluntarily. Ms. Delaney, would you summarize the evidence, please?
Yes, Your Honor. Had the state proceeded to trial in this cause, the state would have proven beyond a reasonable doubt that on or about the 7th day of March, 2020, and continuing until on or about the 23rd day of March, 2020, in El Paso County, state of Texas, Raul de Souza Barreto did then and there with intent to establish, maintain, and participate in a combination or in the profits of a combination with Thiago Alves and Rene Augusto Jr. did then and there commit the criminal offense of theft greater than or equal to $150,000, less than $300,000, pursuant to one scheme or continuing course of conduct. The state offers into evidence State's Exhibit Number 1, the defendant's rights.
Ms. Delaney, you're breaking up. Ms. Delaney, you're breaking up. If you could start, I think, back where you were offering exhibits. I think that's where it's.
Yes, Your Honor. The state offers into evidence State's Exhibit Number 1, the defendant's rights waivers and judicial confessions. State's Exhibit Number 2, the 3914 disclosures. And State's Exhibit Number 3, the indictment in this case.
Any objection?
And the plea recommend.
Without objection, State's Exhibits 1, 2, and 3 are admitted. What is the plea agreement?
Yes, Your Honor. 8 years to serve in the Texas Department of Corrections Institutional Division on the lesser included offense of theft.
Mr. Mesa, is that your understanding of the plea agreement?
It is, Judge.
And Mr. Barreto, is that your understanding as well?
Sim.
Understand that the plea agreement is not binding on the court. However, if I were to reject it, I would allow you to withdraw your plea. If I follow the plea agreement, you may not appeal this case except on matters raised by written motion and ruled on before trial or by permission of the court. The next document I'm going to ask you about is the one-page document entitled The Trial Court Certification of Your Right to Appeal. It is a document that explains your appeal rights. Because this is a plea bargained or negotiated case, you do not have an automatic right of appeal. Mr. Barreto, do you recall reviewing the trial court certification with your attorney and signing that document?
Sim, senhora.
It was signed by your attorney and signed by me as well. So on your plea of guilty and the evidence introduced at this time, I will accept your plea and find that the evidence substantiates your guilt. I will find you guilty of the lesser included offense of theft in an amount between $150,000 and $300,000. And I will sentence you according to the plea agreement to 8 years confinement in the Texas Department of Criminal Justice Institutional Division. You will receive credit for any and all time that you have served. Is there anything further, Ms. Delaney or Mr. Mesa?
Nothing further from the state, Your Honor. Thank you.
Nothing further from the defense, Judge. Thank you.
Thank you both. Good luck to you, Mr. Barreto. Thank you, Mr. Mines.
Ok.
All righty. Who's next, Chewy?
Okay, Judge Brenda
Oh,
Guillen.
take off the interpreter function, I guess.
Annex, if we can get Brenda Guillen Roa, are you handling both cases on Mr. Gomez?
No, Andrea Crespo is going to handle the 2021
Okay,
case.
then we could take care of Mr. Gomez, Judge, if you'd like. Annex, I'm sorry, we could get Kevin Gomez next, please. Kevin Gomez.
Yes, sir.
Thank you.
Okay, wait a minute. Let me ask, what are we doing on Mr. Gomez? Because I can do it, but yes.
Your Honor,
Mm-hmm.
so I know Samantha Rago, when I spoke to her, it was going to be 6 months state jail on her case. And then my case would be same thing, 6 months, and it would with a plea of true. And I did send the Stipson waiver on my case. So I'm
But did
not-
I get him back signed? That's what I don't have. And I thought Mr. Lozano sent me an email back, sent everyone an email back saying I thought he was staying on probation, right?
I did see that email yesterday, Your Honor. I am covering the
And that's what really threw me off. Plus, I thought it was 7 months, but look, I
I'm
was under
showing
the
7
impression
months.
he was gonna stay on probation. That was Mr. Lozano to Ms. King, copying everybody.
Your Honor, I was just going to follow Ms. Rago's rec, and her rec was the 6 months. And my understanding when Mr. Lozano and his client accepted that rec, so it wouldn't make sense to continue and extend my probation while he's doing time.
Mr. Mesa, can you enlighten us on what your client wants to do?
Yeah, Judge, I was actually just going to check with Caesar super quick because I did see the discrepancy as well.
So that was my thought when I saw the discrepancy was let's just push it back a week or two and figure out what's going on, because if what he's doing is pleading to time on the new case, I certainly didn't think we were going to keep him on probation. So you all let me know. What do you want to do?
Just give me 1 minute, Judge. Walk to the
Sure.
next room. Okay, give me 1
Sure.
second.
So,
If I'm not mistaken, I'm showing 7 months on the plea papers I received from my colleague. So I'm not too sure if there's a
right,
difference.
it was 7 months. But I'm not sure where the disconnect is if defense counsel is thinking he was going to stay on probation because they already signed him up for 7 months on the new case. So. Yeah, I think in any event, we just reset him because if they want him to stay on probation, we're gonna have to flesh that one out since I already have plea papers. And if they want to do the 7 months, we need to complete the plea. We need to complete the plea of true plea papers because they haven't done those yet. So I think we should just move on to the next one, should we?
Yes, Judge. Annex, if we can go ahead and get Brenda Guillen, please. Brenda Guillen.
Yes, sir. Go ahead.
Oh, but he's not there, is he?
Mr. Mesa.
We moved on to Miss Guillen.
I can handle that one too, Judge, and then
we can talk. Here's the thing. I mean, if you guys want him on probation, that's going to be a whole other discussion because you already signed him up to the time. And if you want to give him the time, I need the paperwork on the time. So
I think that was what we said, right? The 7 months, and he should be time served on that. And then keep him on probation. But obviously we need to have that conversation with you.
yeah, see, and that's where I'm a little stuck. I'm not sure I want to keep him on probation. See, AOC, because I mean, you all know. I think everybody handled Mr. Gomez's probation case. All three of you did. That was a lot of hand holding, and I'm not real psyched about having him plead on this new case, just so I can go back and hold him some more for another, I don't know how long he's on, what, 5 years, 8 years, something like that. So maybe we need to get on the same page with Mr. Gomez.
Understood, Judge. I mean, if
Okay.
Okay.
All righty.
So
So
we
we'll
just
put
get
it,
back on the probation case, and then that way we can discuss with him.
Sure.
By the time we come back.
sure. So Ms. King, yeah, we need to look at, I mean, he can't mirror it, right? It's got to be a little bit different. So think of a rec get with them on a rec on the probation case. And we'll see where we are. Okay. Thank you, Mr. Gomez. We'll come back in 2 weeks. Thank you, Ms. Crespo, if that's all you had. And now we'll go to Ms. Guillen.
Okay, next we're ready for Brenda Guillen, please.
Yes, sir.
Sorry about that, but there was some confusion. All right, there's Ms. Guillen. Go ahead.
Yes, Judge. Cause number 2017-0D06382. Cause number 2022-0D00206. State of Texas versus Brenda Guillen. Announcement, council, please.
Bella King for the state of Texas.
Eric Meza for the defense, Judge. We're ready to proceed.
And Ms. Guillen is appearing from the jail annex. We're scheduled for a bond hearing. You may proceed, sir.
Thank you, Judge. We're here on a probation case as well as a new case. Probation case is on the AFV from 2017. The new case is an injury to child, elderly, disabled. And to be transparent with the court, there is also a 2022 P file theft of service case that she's recently been booked on. A little background on Ms. Guillen, Judge. She's born in Juarez, but she's raised in El Paso. She's not a U.S. citizen, but she does have a citizen/green card. She's born in 1988, 34 years old, and she's married to Mario Guillen. They have a daughter, Taylor Bustamante, who's 15, and is also the CW on the injury to a child case, who's living at home with mom. She was employed. She was working at household furniture in the claims department for about 6 months prior to incarceration, Judge, and she will have her job upon being released. She has not gotten her GED yet, but she is in the process of attaining that. The address locally in El Paso is 7123 Orizaba Avenue, Unit B, and that's 79912 on the west side. And she does live there with her husband, Mario, as well as her daughter, Taylor. And if we've spoken to her about, the conditions that the court may impose, and she does have an alternate address if necessary on Chapel Run, and that's 79936. That would be with her mom. Now, in the past, as far as mental health, Judge, she has been diagnosed with bipolar and was taking medication at one point, but she stopped because they were making her sick. So she was in the process of reevaluating that, and she was receiving services through Emergence. As far as the new case, Judge, I do know that there was a CPS investigation investigating negligent supervision as well as physical abuse. The negligent supervision was ruled out conclusively, and the physical abuse, there was not a determination made. It was unable to determine. As kind of just additional, she did complete anger management, TAP, and she was evaluated through EHN. So she's been taking steps as far as that. We, obviously wanted to get her a bond, allow her release on probation, and then I'm hopeful that we can get this case worked out pretty swiftly considering the CPS investigation.
All right, Ms. King.
Your Honor, the state respectfully opposes the bond. So a little criminal history. We have 2005 interfering with emergency assistance. I don't have it's unknown disposition. Another 2005 assault family violence. September 2005, another assault family violence. However, that one was dismissed. 2008, there's an aggravated assault, family and house with a weapon. I don't have a disposition for that. On the same offense date, there is a assault family violence with a conviction. I believe she was revoked from probation. 2017, there's an assault family violence with previous conviction, and this is the one for 5 years deferred. Your Honors, the complaining witness in this new case is actually her child, who is 14 years old. On the 2017 that she was placed on 5 years deferred, the victim in that case was her husband, Mario Guillen. And as defense counsel stated, there is a pending theft of service between $100 and $750. I was also notified by Ms. Collar there might be a public intoxication. I'm trying to confirm that in 2020. And therefore the state respectfully opposes the bond.
So, in terms of the new case, I'm just kind of looking through some of the information. It was indicted in January, but the date of offense is back in April of 2021. So what has been going on? I mean, clearly we've gone from April to now. Maybe CPS has been involved, but you know, it's the complainant is her daughter, right?
Yes, Your Honor. And that was screened by the Special Victims Unit in our office. From what I see, I'm not too sure why, but I do see that CPS was involved. So I don't know if they.
Have you had any contact with the family? I mean, have things been, you know, is there a CPS plan in place that is keeping things stable? Go ahead, Mr. Mesa.
I was just going to say, you know, part of the CPS plan, you know, this was the anger management, the TAP, the EHN, that was all part of working with CPS. And I can pull it up, the determination, the case is closed. And so it's because it's been so long. And that was June 28th of last year. So it's been closed and this has kind of been a done thing. And they have had no issues whatsoever. You know, I'd like to remind the court, you know, the allegations are of her disciplining her daughter.
What is it? I haven't gone there. I was just looking at dates of offense right now. What is it?
Of hitting her daughter. I believe punching and then maybe some other form, if I remember correctly. But it was, and that's where you see the physical abuse allegations and CPS investigation. You know, they spoke to everyone that was there at the family gathering where the alleged incident occurred, and CPS has made their findings since June of last year. And so obviously the DA's office is now prosecuting, so we understand the delay. However, the home situation has been, it's been under control for a while. And one other thing, Judge, I do believe, you know, my office has spoken to the probation department, and they've indicated that they do want to keep working with her, that she's been doing well. There have been no issues aside from these new, the new cases. Sorry.
Carla, can you, hold on a second. Carla, can you tell me, because I know I just got a motion to adjudicate from the state, like literally as we are Zooming, I'm getting these. Do you have a case summary on Miss Guillen? I feel like I've seen her name more than once in the past few days. I think, yep, here it is. Bond hearing, no, let's see. Yep, case summary, Monday, 3/14. Ms. Ortiz sent it. She's on 5 deferred. Case screen for family violence caseload. She completed anger management TAP. She was successfully discharged from family violence caseload back in 2019. Has she ever been, I don't see her as ever having been screened for like MHI caseload. Has that ever been a concern?
See anything about it either, Judge, and I haven't discussed that. I mean,
To my knowledge, as for the report received by the officer, Judge.
Okay. All right, Ms. King, you were going to say something. I'm sorry.
Yes, Your Honor. So it's not only the allegations of the physical abuse with this complaining witness in the new case, her daughter, but it's also the verbal abuse. I mean, because we do have the statement from the daughter in this case.
And so, but I guess my question is, you know, what, I mean, you know, in terms of a bond, what resources does she have towards a bond, Mr. Mesa?
not many, Judge, and not much, I'm sorry. You know, based on the conversation with her husband, Mario, That's all they said. They've been trying to get resources, but they're trying to scrounge up as much as they have, but I haven't gotten a set number, Judge. And, you know, if the state does have, or if the court does have concerns about that, you know, like I said, we could definitely impose a restriction where she doesn't, you know, stay at that house and she's staying with her mom, if that's, you know, something the court deems necessary.
So part of her current bond order, if I'm not mistaken, is that she have, let me go back because I don't want to misspeak. I think it's to have no physical contact. Oh,
Your Honor, actually, I did confirm that there is a public intoxication. And the offense date for that is
okay.
August 16 of 2020. And
Okay.
that was not mentioned in the violation notice we received or the summary.
Okay. So her current, she's on a, as I guess since we haven't had the motion to adjudicate, she's not being held on the probation case. She's only being held on the injury to a child. She's got a $5,000 split bond, $4,000 cash surety, $1,000 PR. She's on, you know, the JMAG standard. She's to have no contact with the complainant. Part of that is also no direct communication with the complainant, may not go near the Orizaba address. That's the home address. She would be able to live somewhere else, Mr. Mesa, or?
Right, Judge.
I'm sorry?
Yeah, I'm sorry. I said that's correct. I have that address.
And she may not go near Franklin High School. So I'm going to go ahead and grant the defendant's request to reduce. I'm going to make it a full PR bond. So it'll be a $5,000 PR bond. She's going to report monthly to the PR bond office. The conditions are going to continue to be the same. No. I mean, do they have contact, Mr. Mesa? I mean, do they have?
Sorry, Judge. I don't think it's been, no, I think they've been abiding by the restrictions, right?
Okay, so no contact with the complainant, no direct communication. So no contact, no texting, no social media, no communication whatsoever with the complainant. You may not go within 200 feet of 7123 Orizaba or Franklin High School. Commit no new offenses. You are not to use any illegal drug or alcohol. You are subject to testing. Let me see what else. Did you say that she was under any kind of, no, I don't believe you did, any kind of mental health treatment or anything like that, Mr. Mesa?
Just as she was taking medication for the bipolar, but to my understanding, she's no longer taking that because it was making her sick.
Okay.
Your Honor.
Yes, ma'am.
Sorry to interrupt. Just really quick. I see that there's also a theft arrest from 220.
I think that's a theft of service.
Yes, okay, so I wasn't sure that was mentioned.
Oh.
And Your Honor, that's still in P file. We are waiting for that case.
But so that's got to be something like, I don't know, cable or electricity or something like that, right?
Are we, as far as what was stolen, allegedly stolen?
The theft of service. Mhm.
It's involving a nail salon, Judge.
Oh, well, we'll have to deal with that. Let me, injury to a child. Is this one of the ones, where's my list? Is this one of the ones that has to have a surety component now on the list?
Your Honor,
Yes.
I believe so.
Yes.
I do have the list in front of me.
Yes.
And
yes.
it's letter O.
Yes, you're right. Thank you, Marissa. So, okay, it's gonna be $100 cash surety, and it's gonna be $4,900 PR bond. Sorry, thank you, Marissa. I should put this list somewhere with those conditions. Okay, She is not to, yeah, so she's gonna have to find another place to reside. She's supposed to keep, may not leave El Paso County, may not change her place of residence. So she's living, I thought, you said maybe something mom or whatever her place of residence is going to be. She may not change that place of residence without court permission. And she is to, you know, she has to check in for all court appearances, all of those things, okay?
Understood, Judge.
All righty. Thank you very much. Thank you, Marissa. All right, who's next, Chewy?
Okay, Judge Garite on page 9, top of page 9.
All right.
It's Salvatore Gavite, but I think he pronounces it Frank Gavitt.
How does he pronounce it, Mr. Williams?
Honestly, I think he goes by Frank Gavitt. But I've been entertained by saying
I'm sorry.
Salvatore Gavite for the last 2 weeks.
Hi, Mr. Williams.
My staff is going to be so happy this case is over and I can stop saying it that way.
Oh, yeah.
I think your dress matches my shirt, Judge. Yours is much less obnoxious than mine.
I had to forego the robe. It's so hot in here. Sir, could you tell, what's your name?
Garita Salvatore.
Okay. All righty, Chewy?
Yes,
Go
Judge.
right ahead.
It's cause number 2017-0D05671. State of Texas versus Salvatore. Frank Garite. Announcement of council, please.
Good afternoon, Your Honor. ADA Andrea Crespo for the state. The state is ready.
John Williams for the defendant, Judge.
And sir, this is Judge Perez. I am going to be asking you questions regarding your plea today, so I need to swear you in. Would you raise your right hand, please? Do you swear or affirm that any testimony you provide will be the truth and the whole truth?
Yes.
Thank you. You can put your hand down. Would you state your name for the record?
Salvatore Frank Garite.
Mr. Garita, as I mentioned, I'm going to be asking you questions about documents you may have reviewed with your attorney, the first of which is marked as State's Exhibit Number 1. Those are the plea papers in this case. Within that document, you're guaranteed certain rights, including the right to remain silent, the right to trial by jury, the right to counsel, the right to confront and cross-examine witnesses, and the right to call witnesses on your behalf and in your defense. Mr. Garita, do you recall reviewing State's Exhibit Number 1 with your attorney and signing that document?
Yes.
And did you understand everything contained within that document?
Yes.
Mr. Williams, have you had more than 10 days to prepare a defense in this case?
I have, Your Honor.
Did you explain the plea papers to your client?
I did, Your Honor.
Do you believe he has understood the admonishments, rights, and consequences of giving up these rights by entering a plea today?
He has, Your Honor.
Mr. Garita, are you satisfied with your attorney's representation of you?
Yes, ma'am.
Mr. Williams, do you have any reason to believe your client is not presently competent to enter a plea?
None at all, Your Honor.
Mr. Garita, have you ever been found incompetent by any court?
No, ma'am.
Ever been examined by a doctor or psychiatrist who has found you mentally ill?
No, ma'am.
Okay. Based on your testimony, your attorney's representations, and my observations of you, I'm going to find that you are competent to enter your plea. Sir, are you a U.S. citizen?
Yes, ma'am.
Where were you born?
Here in El Paso, Texas.
So the charge against you, actually, the indictment charges you with count 1, possession of a controlled substance, and penalty group 1 in an amount less than 1 gram. To that charge, what is your plea, guilty or not guilty?
I'm guilty.
In count 2, possession of marijuana in an amount between 50 pounds and 2,000 pounds. To that charge, what is your plea, guilty or not guilty?
I'm guilty.
Judge, he's already pled guilty. This is a probation violation, I believe.
It is?
Oh, no, you're right. I'm sorry, Judge. I'm confusing it. That kind of week. Sorry, Judge. Never mind.
I hear you.
Just ignore me. Everybody should always ignore me, but I apologize.
That's okay, Mr. Williams. So are you making each of your pleas freely and voluntarily, Mr. Gill?
Yes.
I will find you making your pleas freely and voluntarily. Ms. Crespo, would you summarize the evidence, please?
Yes, Your Honor. Had the state proceeded to trial on the indictment on count 1, the state would have proven beyond a reasonable doubt that on or about the 27th day of September 2017, and anterior to the presentment of this indictment in the county of El Paso and state of Texas, Salvatore Frank Garite, hereinafter referred to as defendant, did then and there intentionally or knowingly possess a controlled substance, namely methamphetamine, having an aggregate weight, including indulgence or dilutants of less than 1 gram, And in count 2, that in and to said court and at said term that on or about the 27th day of September 2017 and anterior to the presentment of this indictment in the county of El Paso and state of Texas, Salvatore Frank Garite, hereinafter referred to as defendant, did then and there intentionally or knowingly possess a usable quantity of marijuana in an amount of 2,000 pounds or less, but more than 50 pounds. The state moves to admit states exhibits 1, 2, and 3 into evidence, states 1 being the plea papers, states 2 being the 3914 disclosure form, and state 3 being the indictment and summary of facts of the record.
Any objection?
No objection, Your Honor.
Without objection, states 1, 2, and 3 are admitted. What is the plea agreement?
Your Honor, the plea agreement is for 4 years confinement in TDC with no period of community supervision, as well as 24 months confinement in the Texas Department of Criminal Justice State Jail Facility, Your Honor. And then I'm showing notes that he should get 45 days for credit for time served in El Paso, Texas. And that I believe it's my understanding he was incarcerated in federal prison since January 29th of 2018. And I believe the intention of the plea agreement was to give the defendant that credit, Your Honor, if possible.
So it's
Yes,
January 2018 until when?
January 29th of 2018 is when.
Through present.
Through present is when he was incarcerated, Your Honor.
And there was an affidavit of incarceration filed on February 28th, Judge. He actually was locked up in Oklahoma from January 28th of 2018, but they filed the affidavit of incarceration in February of 18.
Okay, Ms. Nieto is saying, I don't know if I can put the time, but the question when it's more credit than the date of indictment. Okay, so I mean, I'll order it. What we might get some pushback from TDC. We'll see what happens. So, but we're showing a start date of January 29th, 2018. Okay, so Mr. Williams, is that your understanding of the plea agreement?
It is, Your Honor.
And Mr. Garite, is that your understanding as well?
Yes, ma'am.
Understand that the plea agreement is not binding on the court. However, if I were to reject it, I would allow you to withdraw your plea. If I follow the plea agreement, you may not appeal this case except on matters raised by written motion and ruled on before trial or by permission of the court. The next document I'm going to ask you about is the trial court certification of your right to appeal. It is a document that explains your appeal rights. Because this is a plea bargained or negotiated case, you do not have an automatic right of appeal. Mr. Garita, do you recall reviewing the trial court certification with your attorney and signing that document?
Yes.
Was signed by your attorney and signed by me as well. So on your pleas of guilty and the evidence introduced, I will accept your pleas and at this time find the evidence substantiates your guilt. As to count 1, I will find you guilty of possession of a controlled substance in penalty group 1 in an amount less than 1 gram. I will sentence you according to the plea agreement, 24 months confinement in the Texas Department of Criminal Justice State Jail Facility. As to count 2, I'll find you guilty of possession of marijuana in an amount between 50 and 2,000 pounds and sentence you there also according to the plea agreement at 4 years confinement in the Texas Department of Criminal Justice Institutional Division. Those sentences will run concurrent with one another and you will receive credit for any and all time that you have served. As we discussed, I will also include the credit for the federal custody time beginning January 29th, 2018. However, that is something that TDC will be calculating, and I cannot guarantee that they will do that. So, but I am ordering it as time to be credited to your sentence. So, we'll see how it goes down the road. In addition to, I know Ms. Crespo mentioned 45 days in El Paso, but of course you're entitled to any credit that you have served. So anything further, Ms. Crespo or Mr. Williams?
No, Your Honor.
State, Your Honor, thank you.
Thank you very much. Good luck to you, Mr. Garite.
Thank you.
All righty, who's next? Take care, Mr. Williams.
Judge, always good to see you. Can I be excused?
Absolutely, take care.
Thank you.
If we can get Alberto Sainz, please. Alberto Sainz.
Judge, I did see your probation officer at the Chance the Rapper show.
He's selling everybody out. Oh, man.
Well, she was selling goods for volleyball. I was actually there in line buying a sweatshirt for my son and my daughter at $100 a pop. I love those kids.
Thank
Clearly.
you, Mr. Williams.
Bye, guys. Thanks.
Oh, yay. Okay. All right. Let me make sure I pull up Mr. Sines' paperwork because this one has a 1245, right?
Where are you?
And it's on 0042. All right, Chewy, go ahead.
Yes, Judge. It's cause number 2022-0D00042. State of Texas versus Alberto Marcelo Sainz. Announcement to council, please.
Bella King for the state of Texas.
And Kristen Romero for Mr. Sines.
Chewy, did you
Judge,
announce?
I'm sorry, there is a second case, Judge.
Mhm.
It's cause number 2021-0D01868. State of Texas versus Alberto Marcelo Sainz. Announcement to council, please.
Bella King for the state of Texas.
And Kristen Romero for Mr. Sines.
Okay, so we have both cases. Mr. Sines is appearing from the jail annex. Ms. Romero, do you recognize your client?
Yes, Your Honor.
Okay, Mr. Romero, Mr. Sines, I'm going to be asking you questions regarding your pleas today, so I need to swear you in. If you would, please raise your right hand. Sir, do you swear or affirm that any testimony you provide will be the truth and the whole truth?
Yes, ma'am.
Thank you very much. You can put your hand down, and would you state your name for the record, please?
Alberto Marcelo Sainz.
Mr. Sines, we are scheduled for pleas in both of these cases today. I'm going to be asking you about documents you've reviewed with your attorney, the first of which is marked for each case, the state's exhibit number 1. Those are the plea papers in these cases. Within that document, you're guaranteed certain rights, including the right to remain silent, the right to trial by jury, the right to counsel, the right to confront and cross-examine witnesses, and the right to call witnesses on your behalf and in your defense. Mr. Sines, do you recall reviewing state's exhibit number 1 with your attorney and signing those documents?
Yes, ma'am.
Did you understand those documents?
Yes, ma'am. Yes, ma'am.
Mr. Romero, have you had more than 10 days to prepare defenses in these cases? And you're muted if you said something.
Yes, yes, Your Honor.
Okay, and did you explain the plea papers to your client?
Yes.
Do you believe he has understood the admonishments, rights, and consequences of giving up these rights by entering pleas today?
Yes.
Mr. Sines, are you satisfied with your attorney's representation of you?
Yes, ma'am.
Ms. Romero, do you have any reason to believe your client is not presently competent to enter pleas?
No, Your Honor.
Mr. Sines, have you ever been found incompetent by any court?
No, ma'am.
Ever been examined by a doctor or psychiatrist who has found you mentally ill?
No, ma'am. Well, I've been to the psychiatrist.
Okay, is there any condition, either diagnosed or any other condition that you're feeling that is preventing you from understanding what we are doing today?
No, ma'am.
Have you been able to effectively communicate with your attorney?
Yes, ma'am.
And you've been able to discuss with her everything regarding your plea today?
Yes, ma'am.
Okay, so based on your testimony, your attorney's representations, and my observations of you, I'm going to find that you are competent to enter your pleas today. Sir, are you a U.S. citizen?
Yes, ma'am.
Where were you born?
New Mexico, Las Cruces.
All right, in cause number 2022-0D00042, you were charged with the offense of burglary of habitation. To that charge, sir, what is your plea, guilty or not guilty?
Guilty.
Okay, in cause number 2021-0D01868, I think you were charged originally with possession of a controlled substance in penalty group 1 in an amount between 1 and 4 grams, but through negotiations, you're pleading to a lesser included offense of possession of a controlled substance in penalty group 1 in an amount less than 1 gram. To that charge, sir, what is your plea, guilty or not guilty?
Guilty.
Are you making each of these pleas freely and voluntarily?
Yes, Your Honor.
I will find you are making your pleas freely and voluntarily. Ms. King, would you summarize the evidence, please?
Yes, Your Honor. Were the state to proceed to trial on the indictment, the state would have proven each and every element of the offenses charged. Burglary of a habitation in cause number 2022-0D00042 and possession of a controlled substance in penalty group 1 between 1 gram and less than 4 grams in cause number 2021-0D01868. beyond a reasonable doubt. Judge, the defendant is pleading to 2 years in TDC to run concurrent with both cause numbers and to 1245 cause number 2021-0C03502 and dismiss cause number 2021-0C02482. And at this time, the state moves to admit Exhibit 1 as the state's plea paperwork, Exhibit 2, Article 3914, and Exhibit 3 as the indictment.
And there's no objection from the defense.
Without objection, states exhibits 1, 2, and 3 are admitted. And Ms. Romero, is that your understanding of the plea agreement?
Yes, Your Honor.
And Mr. Sines, is that your understanding of the plea agreement as well? I'm sorry, I couldn't hear you.
Yes, Your Honor.
Okay, so understand that the plea agreement is not binding on the court. However, if I were to reject it, I would allow you to withdraw your pleas. If I follow the plea agreement, you may not appeal these cases except on matters raised by written motion and ruled on before trial or by permission of the court. The next document I'm going to ask you about is the one-page trial court certification of your right to appeal. It is a document that explains your appeal rights. Because these are plea bargained or negotiated cases, you do not have an automatic right of appeal. Mr. Sines, do you recall reviewing the trial court certification with your attorney and signing that document?
Yes, ma'am.
Signed by your attorney and signed by me as well. Now, as or under cause number 2022-0D00042, there is an additional document regarding section 1245 of the Texas Penal Code. And this is in regards to cause number 2021-0C03502. It is a misdemeanor offense of driving while intoxicated. That document appears to have your signature, and it is regarding your admission of guilt to a driving while intoxicated that occurred on January 14th, 2021 in El Paso County, Texas. Do you recall reviewing that document with your attorney and signing that document, sir?
Yes, ma'am.
And you're aware that by signing that document, although it is not going to be an adjudicated offense, meaning that you are not going to be found guilty, you are making an admission that you committed and in fact are guilty of that offense. You aware of that?
Yes, ma'am.
Okay, and as part of that, the court is considering that in your sentence for cause number 2022-0D00042. Do you understand that?
Yes, ma'am.
Okay, and so that was signed by you and by your attorney. Basically, that is a dismissal of that misdemeanor cause number to be considered in this felony plea. So on your pleas of guilty today, sir, and the evidence introduced, I will accept your pleas and at this time find the evidence substantiates your guilt. In cause number 2022-0D00042, I will find you guilty of the offense of burglary of habitation, and I will sentence you according to the plea agreement to 2 years confinement in the Texas Department of Criminal Justice Institutional Division. In cause number 2021-0D01868, I will find you guilty of the lesser included offense of possession of a controlled substance in penalty group 1 in an amount less than 1 gram. And I will sentence you according to the plea agreement and in accordance with 1244A of the Texas Penal Code to 53 days confinement in the in the El Paso County Detention Facility. These sentences will run concurrent with one another and you will receive credit for any and all time that you have served. Is there anything further, Ms. Romero or Ms. King?
Nothing further from the state, Your Honor.
Nothing from the defense.
Good luck to you, Mr. Sines. There's nothing further. We're good to go. Thank you, Mr. Sines.
Thank you.
Thank you. May be excused, Your Honor.
You may. Thank you.
Thank you, Judge.
Do we have Mr. Thomas or Annex? Do we have Mr. Thomas there?
Yes, ma'am.
I want to quickly just. Is anyone here for Mr. Thomas? I want to get on the record very quickly.
No, Judge, Mr. Darnell is not on, and he's not in the
Okay.
waiting room.
Okay. Ms. King, are you handling this one?
Yes, Your Honor. It was already
Hmm?
It was already troubled, I believe, on 7 counts this morning.
So I just want the record to reflect that we're here. Mr. Thomas, is that you?
Yes, ma'am. Yes, sir.
Okay. So let me go ahead and just call it very quickly. Calling cause number 2022 DCV 0687, Jaden Thomas versus the state of Texas. Just for purposes of the record, because we did have Mr. Thomas scheduled today, I wanted Mr. Thomas to be aware this was set for hearing today because your attorneys had filed a writ, but had indicated that they had some of it unavailability. And so I scheduled this just in the event we were able to have someone here from their office. We do have a backup date, though, I believe of Thursday morning or Friday morning, Chewy. Do we know? I'm drawing a blank right now.
I believe it's Friday, ma'am.
It's Friday
Yes,
morning.
Judge, it's Friday morning at 8.
Okay, Friday morning at 8 a.m. And mostly that is because of the logistics of scheduling outside of our one assigned window with the jail. Okay, so I will refer you to your attorney, but we do have a subsequent hearing. I am now seeing it. It's on March 18th at 8 a.m. Okay, thank you very much. We are adjourned. Okay. And if that's it.
Judge, let me, I believe they might even have Daniel Valles. I'm not sure.
Daniel Valles. No,
Nope.
Daniel Valles, because he's still not transferred back from the 384.